welcome back to another edition of the Dirty Verdict Podcast. I'm here solo, Peter Taaffe, missing my co-hosts Bill Ogden and Kyle Herbert, as it is summertime and they have younger children, so they're out. But I'm fortunate to be joined by Steeves Hopson.
Peter, good to see you.
Good seeing you, of the newly created Hopson law firm.
Hopson Injury Attorneys, that's right.
Excellent. Where can people find you online?
At hopsoninjuryattorneys.com or on social media as well, on Instagram, LinkedIn, Facebook.
Excellent. Okay. And so a couple of things as far as topics, we usually do legal news or interviews with lawyers. We've had a couple in your situation who had recently left very good firms to start their own firm. And so you and I have been friends for a while and mediated for you in the past. And so, and I came to your grand opening reception. I was very impressed with how you've done things since you've opened the firm. So I thought he'd come on. And on top of that, right before you opened the firm, you had a string of 3 very successful jury verdicts that I hope we could talk about.
Absolutely. Sounds good.
All right. Well, starting with your background, briefly, I know you're originally from Laredo.
That's right.
All right. And then you have some legal connections in your background.
That's right. So I'm one of 7 lawyers in my family. And my mom, several uncles, cousins. In fact, I have 3 cousins who also went to the University of Texas and then the University of Texas School of Law, one of whom is a big mentor of mine. Her name is Julia. So shout out to Julia.
Hello, Julia.
And she and I were in law school together at the same time. Also a great trial lawyer. So yeah, I have laws in my background and it's kind of the family business.
Yeah. So your mother was at your reception and she was a long time. Is she still practicing?
She off and on. So she's semi-retired. She does little appointments here and there, but my mother for many years was in big law and she made her way up to partner as a single mom with 3 kids. So I'm very proud of her. And she did international trade. So not a litigator by trade, but got a lot of other litigators in the family.
Who did she work for?
She was with Jenkins and Gilchrist at first. And then they shut down, and then Jackson Walker, and then Strasburger, who I think has been bought out, or the name has changed since then.
I think they're Clark Hill.
I think that's right.
So was she San Antonio, or where was she?
Yes. So she's also from Laredo, but moved us up to San Antonio after our family business closed. She was the CEO, and then decided to go to law school at St. Mary's, and the rest is history.
Nice. And then your uncle was a DA?
Yeah. So my uncle Joe Rubio was the DA in Webb County until 2008. He had 20 years there as the DA. And then ultimately I decided to, and I'm skipping ahead a little, but yeah, I sort of followed in his footsteps along with my cousin Julia and was a prosecutor under the next DA, who is still the active DA in Webb County.
Got it. Yeah. So UT undergrad and then where for law school?
UT Law School.
Got it. And then went straight to the Webb County DA's office?
So I did a short stint in San Antonio in employment law and realized that wasn't for me. I wrote a bathroom device use policy and realized, okay, I don't think I want to do this for the rest of my career.
What's a bathroom use device?
So evidently there were salespeople for a particular client who were taking calls while doing their business. And once I realized that was the kind of thing I was going to be doing, I thought, let me try something different.
So something beyond just like, hey, don't use your phone while you're on the toilet.
Exactly right. And my cousin Julia, actually, and you'll hear her name scattered throughout this because she's had a big impact on me. But she recruited me to go work as a prosecutor and said, hey, come kind of see your roots again, get in the courtroom. And she had already had a few verdicts under her belt. She was on the mock trial team at UT Law School. And so I packed up my things and I went and had a great experience.
How many years there?
I was there for 4 years.
Okay. And then at some point you made a decision you wanted to move to Houston and go into personal injury law.
That's right. So COVID was a big part of that. So I was in the most trial intensive, but also most emotionally taxing unit at the DA's office at the time, the special victims unit. And for those who don't know, that's sex crimes, crimes against children, crimes against the elderly. And really the whole purpose of going to the DA's office was to get experience. And COVID really hit Webb County hard, and Webb County shut down for, my understanding, is a lot longer than other counties. So that experience dried up and I decided it was time for a change. And just decided on Houston. And I thought personal injury was sort of the most natural next progression as someone who had already been in the courtroom, helped out on a lot of trials, first chaired a trial, and here I am.
Yeah, so you came up here. It was your first job with Brian White?
That's right.
Former guest of the show. I don't know if you've seen that. He dressed up as Beetlejuice.
I did not see that. I have. He is known to dress up, so that does not surprise me.
Yeah. And then next stop was,
I was with Johnson Garcia after that.
got it. Okay. And then your most recent firm before you opened was PMR.
That's right.
All right. So going into your decision to go on your own, how'd that come about?
Well, I come from a family of not only lawyers, but also leaders and entrepreneurs. My dad runs a transportation business, and my mom was the CEO of our family business when she was 25, all the way till she was, I think, 32, 34.
Uh-huh.
And I always kind of knew that, I've been independent minded and some would say stubborn. And I realized that at a certain point, I was not going to be where I wanted to be in life and have the freedom to do the things that I wanted to do in life unless I was on my own. So really it was, at first I thought, well, what do you need to go on your own? And a big thing that I heard over and over and soaked up sort of through osmosis was you got to be able to get clients. And I was fortunate enough to bring in nearly 15 when I was over at PMR. And I thought, okay, well, that's one box that I checked. And then, get that experience. At PMR, there were great lawyers there. I learned a whole lot from a guy named Wade Moriarty, who was the president of HTLA, the Houston Trial Lawyers Association, who was supervising me over there, among other people. And so that and then trying cases and, getting good verdicts really gave me the courage to go ahead and go for it.
Yeah, this is, I think, a great time for young lawyers to start their own firms because you can very efficient right now. A lot of stuff being done by Zoom, social media. And we'll talk about that in a second. Social media is free; just takes your time. You don't have to pay for advertising unless you want to.
Right.
And I also, particularly in Houston, I think the lawyers on the plaintiff side, notably, as guests have talked about it, are very collaborative with each other. You don't have to be at the same firm to work on a case together.
Right.
So for a young lawyer, anyone who's kind of thinking about it or toying with the idea, either side really, what kind of advice would you have as for what you've, 2 months in now? What would you do? What would you advise? What would you maybe say that was a mistake, or I'd maybe do that differently?
Sure, absolutely. So there's I'll call the sort of unsexy part of it, the reality of numbers and savings and things you got to consider. And then also you have to have a clear plan for client acquisition, and you have to have good mentors in place. Otherwise, I think you'll be lost in an ocean. So you, first of all, need to save your money. You got to know, my goal was at least 9 to not 12 months of savings. And I have a very supportive girlfriend who, encouraged me to move in with her, and I was able to save a lot of money that way. And just sort of prioritize saving instead of maybe I skipped dinners, I skipped trips because I knew I wanted to do this. So that's one thing. You got to save your money. Otherwise, the pressure, you need that to survive, and you need to invest in your business, particularly at the beginning. But also, the more financial pressure you feel, the less, I guess, effective you'll be as a business owner, as an attorney. So it's best if you give yourself that cushion. That's number one. Then you got to figure out, what's my brand? What's my place in this massive market full of PI lawyers? And for me, it was, and I think I'm, good with people. I know how to try cases. I'm not afraid to do it. And then ultimately, as I'm sure we'll talk about, I was successful at doing that. So I thought, okay, I'll try cases. I can get clients. And I realized that if I'm available to clients, and if I'm transparent and I'm honest with them and I sincerely want to help, that will help. Now, I also speak Spanish as a first language, and I've marketed myself as sort of the Spanish-speaking gringo, which is how I've distinguished myself from maybe other competitors. So that's important. And then mentorship is really important. So I've had the good fortune of having 2 great parents, one of whom is not a lawyer, but has, done well in business and has had really low points in life, and has done really well other times. And that's very important because it teaches you how to stick it out and also how to handle success. And then I've had lawyers, and I'll name one of them, Jimmy Sanoski, who was the guardian ad litem. And for those of you who don't know, it's essentially a court-appointed lawyer who approves or disapproves of a minor settlement before the judge ultimately decides whether or not that settlement is best for the child. And we got to talking, and he kind of figured out that I had the itch. And since that day, he's encouraged me and been an open book. So he's a big one. And then just other lawyers where when you tell someone that you trust, I want to do this, I want to go on my own, I want to be like you, I was shocked, frankly, by how helpful everyone was, and couldn't have done it without them. So you got to know how you're going to get clients. You got to save your money. You got to know how you can differentiate yourself from other people, and you got to have great mentors.
Got it. And then did you do like a bank loan or a line of credit in addition to your personal savings?
No, so it's all personal savings, and then a business credit card, of course. But as you mentioned earlier, you can do this really lean. So I use a co-working space. I've got a little shoebox office, and that to me is a badge of honor. Before I really knew how other people were doing it, I thought you needed a big fancy office. There's nothing wrong with that. It's nice, it's impressive, but it's not necessary. So you can keep your costs really low by using things that are free, like social media, like you mentioned, and also just getting out there in the community. And then everything else, if you have a computer and a cell phone, that's pretty much all you need to get started.
And a Wi-Fi connection.
That's right.
Yeah, I saw you post on LinkedIn today. It's kind of, I mean, when you don't have a paralegal or legal staff, you have to learn yourself.
Right.
And yeah, as a mediator, I'll file like notices of settlement. I never e-filed things before, so I had to learn how to do it at the beginning. I'd go to Pacer, learn how to file things on Pacer. It's not that hard, but you just have to learn how to do it and be forced to do it.
Well, that's right. And I'll tell you what, I had one friend who won on his own and up in Austin. His name is Ryan Hecht. He told me, you don't realize how much more efficient with your time you're going to be when you got to complete tasks to get paid. And he was right about that. So when you look at it like, what do I have to do to complete this task and to then complete the next one to ultimately move this case or get it ready for trial? Once you get that mindset shift, then which is what happened with me, then it's really not so bad, because all you got to do is, you don't know how to do something, you pick up the phone, you call a buddy. And I've done that. Hey, I don't know, I've never filed a lawsuit before. I've drafted one but never filed one. Pick up the phone, quick 30-second conversation, and then you just learn how to file a lawsuit. So if you break it down into small steps and don't get overwhelmed, it's 100% doable.
Yeah, good. Okay, and then as far as your marketing, you talked about, you got to kind of figure out what your brand or your niche is going to be. So what have been your thoughts, or what's been your approach to marketing as you begin your firm?
So if I could use one word, I would say grassroots. And I've always been a very transparent person. I'm, a vulnerable person, which I think is a sign of strength. And, I like to be real. So that is sort of the overarching theme of my marketing. And the best way to show that you being yourself is to sort of expose yourself to the public. And you can do that through social media, through my own personal social media. LinkedIn has been really good for me because I can, say things that I think are interesting on social media, on LinkedIn particularly. And showing that I'm, real people are just happen to be lawyers has been, I think, a real asset. I actually, and you have to look around you and always be open to inspiration. So I'll give you an example. One of my best friend's mother told me over dinner not too long ago that to her, lawyers are intimidating. And that stuck with me because, I know all kinds of lawyers, lawyers. We're not necessarily intimidated by them, but non-lawyers might be. So if you can show, hey, I have a dog too. I like, sports too. I like music. I also sometimes feel self-doubt, which is something that I talked about on LinkedIn. Then people relate to that. And then you show them, hey, I'm just a guy who happens to be a lawyer. So that's been sort of the big thing. And then also, anytime I'm at a restaurant, anytime I meet somebody new, anytime I really do anything, I always make it known somehow that, hey, I'm here to help. And one thing that I'll do that, none of this is rocket science. I try to be the go-to lawyer for anybody that I meet. Obviously, I don't practice every type of law, but I can easily find somebody who does. So if you're that person, then the new person that you meet now feels special because, I have a lawyer now, which is a great way to make a connection, but also all of their legal questions run through you. So it's that constant loop of anytime they know they need something or someone they know needs something, they're constantly going back to you. And eventually something in your niche will come around.
You give a bunch of cards out?
Yeah, and I use a digital card. I'm thinking about printing cards, but I found that a digital card is great. I use Dot in case anyone's interested.
What's it called?
It's called Dot, like dotting your T's, dotting your I's and crossing.
It's an app called Dot?
Yeah, so it's an app and a physical card called Dot. And it helps me because when someone saves your contact information, it tells you when and where you met them.
Oh, good.
So it's very helpful. And I give everybody my cell phone for now because to me, that's the best way to show, hey, I'm accessible and I'm not going to route you through a receptionist or, something like that. Of course, eventually, when we grow, then there will be no choice. But for now, this is how you contact me directly. And you have an ally. And if you have any kind of question like immigration or, God forbid, a criminal defense question or anything like that, then I'm going to help you or I'm going to send you to somebody who can help you.
Good. Yeah, that's the thing is like LinkedIn, I've noticed that's become a lot bigger with lawyers recently. And incidentally, the Dirty Bird podcast has a LinkedIn page. I post the episodes every time they come out. So I've been on there a lot recently as I've done that. And so, yeah, I think that's wise to get up there and you see when you post, you can see how many impressions your post got and you can kind of see what works. And I mean, there's no metric to figure out how many people saw your billboard,
right?
For instance, I mean, you can guess based on the traffic or whatever, but LinkedIn, you can see real time, what's kind of getting traction and what's not.
Well, if I can add to that on LinkedIn. So for me, LinkedIn has been a great way to get to know guys and gals in other regions, other markets. And in my experience, not only can you make a friend, which to me is always great. I've never met a stranger, but in my experience, and it seems, logical to me, if you connect with someone in Atlanta or in Santa Fe or in New York, wherever, and you really build a good connection with them, the likelihood of that person really spilling their secrets and giving you the unadulterated truth is a lot higher because you're not direct competitors. And at the end of the day, it's the same game. Now the law is obviously different in a different state, but negotiations are the same. It's the same concept. Making strategic decisions is more or less the same thing. So you can really widen that net of mentors and friends and people to bounce ideas off of tremendously if you avail yourself of LinkedIn.
Yeah. Were you telling me there's a lawyer that who's pretty successful who gave you a bunch of time and advice that you met via LinkedIn?
That's right. So there's a guy named Hunter Garnett, and I'll have to send him this when it comes out. He's out of Huntsville, Alabama, and we've become buddies. He's very successful. We're about the same age. And we agreed to speak at around 6 o'clock in the morning, local time. And he was feeding his horses while we talked, and he gave me so much golden advice. The guy's a genius at marketing, and he pretty much dominates that area. And without him, I wouldn't have had so much knowledge to know maybe where I ought to have my office, or who I ought to reach out to, how I ought to reach back out to people. So I mean, exactly, he's someone like that is a great example of how LinkedIn works.
Good, yeah, I follow him too, so his posts come out quite a bit.
Yeah.
Okay, so let's talk about these 3 recent verdicts you got right before you open your firm. And I'll take them in whatever order you want. The most recent one was a dog bite case in Austin.
So yeah, let me clarify something.
Yeah.
So there were 2 verdicts before I went on my own.
Yeah.
And then the dog bite case, the most recent one was after I had started my firm, but it wasn't my case. So I was trial counsel on that one.
Okay.
So we can go, I guess, in chronological order.
Yeah.
So we'll start with the first one. The first one was a car crash involving the county. So it was a TTCA case. The Texas Tort Claims Act, which basically is a overly complicated way of saying there's a cap on damages. In this case, $100,000.
Okay.
And
every governmental entity has a different threshold.
Correct.
But counties, I think by statute, it's $100,000.
That's right.
Max. That's the most. You get a $500,000 verdict. The judge is going to have to reduce that by law to $100,000.
That's exactly right. And so those are tough cases. Those are often, in my experience, and from what I've heard from those who are more experienced, trial cases typically. I mean, unless someone is dead, or a severed arm or something.
There's no Stowers doctrine against the county.
Correct. And so, that case was interesting because it was a county employee who decided that he was going to do a U-turn on a busy school road, so narrow road, while school was letting out. And the whole deal there was he was not patient enough to go up, turn in somewhere, and go around. His shift was about to end, so he wanted to just pop a Yui and leave. Now, with that one, it's interesting because we went about 90% of the way through, and then we ended up getting a mistrial. And so it's a long story, but we used
Harris County District Court.
That's correct. Harris County District Court, and got a mistrial because the vendor that we used sent us an interpreter whose license had elapsed. And we didn't know that. We didn't think to look into it. So friendly tip, always check.
How did it come up?
It came up because the opposing counsel, I didn't know this until it came up, but he noticed that one word was not translated. And the word was bien, which means good. And to me, it was innocuous. But the opposing counsel made a big stink out of it because of the context. It had to do with damages.
Was the opposing counsel fluent Spanish speaker?
I learned that he is. I didn't know. He kept that close to the vest. But yeah, so we argued about it. And of course, I said I don't think it was a big deal. The judge then went back in chambers and listened to a recording that the court reporter had done, an audio recording, and decided that it was material, and that it was grounds for a mistrial. And so there's no better trial than when you've seen what your opponent is going to do and they've seen what you're going to do. So we retried the case in April, and all the cards are on the table. And basically what I thought to do was, let me take my opposing counsel's theme away from him. And it was basically the effects of being impatient, right? The consequences of being.
What was his theme in the first?
That's exactly what it was. So he claims that my client at the time tried to squeeze behind this truck as it was stopped, about to finish a U-turn. Well, the damages didn't show that. My client's testimony obviously didn't say that, and it doesn't make sense. So what I thought was, wait a minute, that's a great theme. So I just took it. And one thing that I did was I used that theme during jury selection. So, I asked the potential jurors, so who here has ever experienced an impatient driver in Harris County? And of course, everybody raised their hand. Harris County drivers are not the best. And I actually grabbed a piece of paper and I erased it like it was a card. And said, so have I. And I then asked, who here has ever been confronted with or seen an impatient driver driving a work truck? And there was one man in particular who raised his hand, who was, I think, juror number 3 or 4. And this is another thing that I've learned about jury selection. You have to capitalize on those moments when it could make or break your case, or it could really help you score points. I noticed this guy, and you have to really pay close attention to what people say, how they look, how they carry themselves. And this guy in particular was a real heavy-set guy. He was dressed to the nines. Everything was tailored. He had on a hat that looked like something Pharrell Williams might wear, which takes a lot of confidence to wear. And my client was a Spanish speaker. I, as a fellow Spanish speaker, can tell when someone's second language is English. And I knew just based on demographic information that this guy was also a Spanish speaker. So I, talked to him. He gave me some good nuggets about how a friend of his was a truck driver and would frequently look at his phone and, mess around while he was behind the wheel. And so I sort of ran with it. And I could tell that not only was this guy going to be good for us if he got on the jury, but that he was also a leader based on the way he carried himself. Well, sure enough, he gets on the jury. And I used a trick that I learned at a CLE, basically, that says, if you look at one person who you want to be your foreperson, they will more than likely be your foreperson during closing argument. That's exactly what I did. And he was our foreperson. So in that case, the pretrial offer was $11,600 on $42,000 in past medical damages. Obviously, that's a non-starter. The jury returned a verdict of $265,000. Now, of course, it was cut. But interestingly, tough case. And you learn so much from trying cases. The jury actually thought that we asked for too little. So when you're evaluating, what I've learned, when you're evaluating cases pre-trial, when you're making an attempt to settle the case, don't be afraid to ask for something close to what it's worth. Of course, you have to make some concessions because that's how deals work. But when you try a case and you hear a jury tell you, we would have paid you $300, that really informs how you do everything going forward. So that's the long and short of that one. I will also say,
has there been a judgment entered? Is it done?
That I don't know. So I left the firm 2 weeks later.
Oh, okay.
So I don't know the answer to that.
Got it.
But yeah, that's some license.
So the verdict amount was how much?
$265 and change.
Got it. How did they break down? They gave full meds, 42.
It was full meds, and I'd have to go back and look at the specific breakdown, but it was full meds, and then let's see, it must have been. I'd have to go back and look at it.
But the rest was pain and suffering.
That's correct. Yeah, and another thing to bring up is, so we used, I think it was $5 per day, $5 per hour, 40 hours per week. And then for past, we went back and said, well, it's been this many weeks since. And they gave us exactly what we asked for there, which was very encouraging. And, and then for future, one thing where I sort of stepped in, it was, I didn't have any sort of, I didn't have any evidence, or I didn't ask the court to take judicial notice of average life expectancy. So that drew an objection. Basically, my thinking was, I'm going to do the same thing going forward until the age of 80. And, those who have tried that more times than I had know that you're going to get something in to substantiate that. But nonetheless, the jury heard I think it was future pain and suffering. And even though I was objected to and for not having any justification for the number 80, the jury heard that number and then awarded the same amount, except for future physical impairment. They actually gave us, I think it was $25,000 more than we asked for.
And this was as on the liability side. This is a swearing match. Both
Correct.
sides.
And the liability was, it was 5% on my client and 95% on the county.
Good. All right. Next one.
Next one was a negligence case that was sort of felt like a med mal case, but it did not involve a licensed physician. So it was just negligence. And we also pleaded gross negligence. On that one, I came in at the very end. So I didn't work on any of the pleadings. I didn't, no motions, none of that. I didn't even do limine, nothing. Basically, I was instructed to go in like a mercenary and try the case. It was a bench trial, and it was in one of the more peculiar and particular courts, district courts in Harris County. Those who know will know which one I'm talking about. And it was a bit of a circus, but essentially we had a client who was partially blind. She had some condition called Leber syndrome, which it is genetic. So it partially blinds you. You have peripheral vision, but the rest of your vision is diminished or completely gone. She was desperate, and she was a very humble, not very educated lady. And she gets convinced by a friend to go to this sort of Hispanic holistic clinic. When she goes, this holistic medicine doctor who's not licensed told her that he had this guy out of Mexico who was this groundbreaking scientist, and he used stem cells, and he was going to restore her vision. And obviously, when you're desperate to see, and someone promises you this, well, then it's understandable that you would fall victim to that kind of thing. So she gets a series of injections, and I think on the 10th injection out of 15, she goes completely blind and went through a terrible amount of pain. It did not rack up a whole lot of medical bills. I believe it was less than $20,000, if I remember correctly.
From actual doctors that were treating.
They're exactly right. And after the fact, that's right. And on that one, I was up against an attorney who said to me on the phone that it was his last case ever, and that he was going to retire and live in Mexico and sell real estate.
Did he tell the jury that at trial?
No, so this was a bench trial.
Oh,
yeah, which I think I mentioned. So
you did.
Yeah, and so I had never done a bench trial before, and very interesting. And this lawyer was, not the most ethical. In fact, he also told me that if you haven't gone to jail for contempt, then you're not trying hard enough, which I thought was interesting. But yeah,
we don't endorse that.
No, definitely no. And
maybe Bill does, but he's not here.
So, he didn't know the rules of evidence. He didn't know the case. And he was being shifty and shady. And I'm typically not a yeller, a screamer, or super aggressive, maybe in bit parts, when I see an opportunity, when someone's lying or they're aggressive with me, it's just not my style. But I made the decision to just hammer him so that I could keep it moving. And I knew that we had a judge who's a little more loosey-goosey, and that if I show that I know the case better, I know the rules of evidence better, then we'll be successful. That's exactly what I did. I went as far as to tell the judge that this lawyer not only didn't know the facts of the case, but clearly had never learned the rules of evidence, and that he was just repeating things that he'd heard in the courtroom and that they made no sense. And that helped keep things moving along. And I put my client testified by Zoom from Honduras, and she's blind, so that was tricky.
And do you have to have someone down there to help her?
No. So we tested her connection several times, and she was testifying from her cell phone. She can't see, so you can't show exhibits, which is tricky. And so we made the most of it. And she, the whole deal was, this is likely a judgment-proof defendant, but we want her to tell her story. She was able to do that, and wasn't exactly sure how it was going to go, but same deal. Asked the judge for, I'd use the same sort of calculation method of X amount per day, for this many hours per week, for this many weeks, and then similar deal for future. If she lives to be this age, here's how much it would be. The judge awarded exactly what I asked for, except for I alleged gross negligence for making that referral from the non-doctor holistic medicine guy to this so-called expert who ultimately blinded my client. And the judge did not go for that because she said that had we actually been able to bring the one who administered the injections to trial, maybe.
Because that person was located?
That person fled to Mexico.
Got it. Okay.
So I skipped that part. They were indicted and fled to Mexico. And they're still, to this day, on YouTube posting videos about how they're so great and how all this technology. So unfortunately, those people exist. But fortunately, people like me as a trial lawyer and obviously my colleagues in the community have the opportunity to help. So that was more of a tell your story, and help someone who really needs it.
What was the judgment on that one?
That one was $625,000. And I think the past meds on that one was about 20, maybe 18,000.
Okay.
And then the most recent one.
Yep. This one, the third one, this was after you'd started your firm.
Right.
And by the way, on the last two, did anyone else try the case with you?
So on the first one, good point. The first one, the TTCA case, Wade Moriarty was second chair. I'm glad you brought that up. I want Wade to get credit. And Wade was a great second chair. Wade has tried, I think, 100 trials. And his style was great because, his whole deal was, I want you to learn how to do this right. And he sort of hands-off approach until maybe he had an important thing to say. So that was really great. Not a ton of notes. Everyone who's been to trial knows that the excessive note passer is not helpful. Yeah. And I've been the excessive note passer, so I get it. But so Wade tried that case with me, and then I had a paralegal from PMR on the second one named Clayton Rainey, who's an aspiring lawyer.
What's the first name?
Clayton Rainey is his name. He was there. He knew the second case very well, and he had worked it up. So he was there helping out with exhibits, and Clayton has a bright future ahead of him. He'll be a very successful trial lawyer at some point.
Okay, so third one was in Austin, and this was with you're on your own, and you've got a good friend,
right?
That's a lawyer up there that he brought you in to try it.
Right. So my law school classmate Ard Ardalan, out of Ardalan, he's with Hopson Injury Attorneys in Austin. We were section mates, and then we sort of stayed in touch. He started his firm, I think, 4 years ago, and once he learned that I was going on my own, he invited me to try this case with him. It was in my second week on my own, and he said, "Hey, there's no money in this. We got pro se defendants on the other side, but let's go see what we can do." He had, and I said yes, because why not? And he had already done a focus group on that case, and he told me this is a loser of a case. The focus group hated it, and I told him, I understand focus groups. I've never done one, and I see the value of it. But just from my perspective, outside looking in, the focus group doesn't have the whole story. They haven't met the plaintiff and they haven't met the defendants. And, it's funny. And when I was driving down from Houston to Austin, I heard an interview with a pro wrestler who talked about the sort of genius of Vince McMahon. I'm not a wrestling fan, but it really intrigued me. And the timing was impeccable because I thought, you know what, that applies to trials. And so when I arrived to Austin...
How would you say it applies to trials?
So it applies to trials because Vince McMahon understood timing. He understood timing. He understood anticipation. He understood drama. And a trial is sort of a theatrical deal. You got to know things like volume, pitch. You got to know how to let silence build. You got to know when to break that silence. You got to know how to move around. You got to know when to be loud and when to be quiet, how to emphasize things, when you should bring something up or when you ought to save it in your back pocket for closing argument. Those same sort of principles apply to Vince McMahon or to an excellent producer or someone who writes movie scripts. Those things apply to trials, in my opinion.
Yep.
So I get to Austin. We're prepping. My trial partner Ard is more. I'm a little more, I guess, have more EQ, and Ard is a little more organized, more structured, and because he's a former paralegal, and he's a brilliant guy, and that combination actually ended up being excellent because, he knew his case super well. He had focus grouped it. He had written the charge, and it was very precise. But I was there to sort of tell him, hey, that's enough, or tone it down, or, keep moving, or keep going, or object, don't object. And, he thought that case was a loser. I told him it might be, but it might not be. And we ended up getting a $198,000 verdict on that one.
And it was a dog bite of a child?
It was a dog bite of an adult. Mm-hmm. And essentially this nice lady, a good Samaritan, was driving in a neighborhood in Austin. She sees a lost dog sign. She herself is a dog lover. A few blocks down the road in this neighborhood, she sees a dog walking around with a collar and thinks maybe it was the same dog. Couldn't remember the exact description of the lost dog. But as she gets out of the car and asks a neighbor nearby who the dog belonged to, turns out the neighbor tells her, I think it belongs to that house over there. The neighbor points to the defendant's home. This lady, or the client, guides the dog over to this house, notices that the dog walks over to this side gate. The gate was slightly ajar. And when she then opened the gate slightly, noticed that this dog didn't go in and that there were two other dogs, a pit bull and a three-legged, some other type of mutt dog. She then says, well, it must be the wrong house, closes the gate, but it won't securely latch. And she walks away. And when she comes back to give this stray dog water and then try to leave, this pit bull owned by the pro se defendants attacks her viciously. So bad that you could see the fat hanging out of her wound. So. And
you said it wasn't covered. Is it because it was a pit bull exclusion on the?
That's exactly right. Yeah. So it was excluded. I think there was a pretrial offer of maybe $5,000 in installments. Of course, that was rejected, and we just went to trial on it.
Yeah, and there's trying cases against pro ses. Some people may think, oh, that's easy because they're not lawyers. But I found I didn't try any cases against them, but when I had a case against them, I thought those were harder because the judge, even though the law says they're to be treated like lawyers, at least as far as their, briefing or whatever, judges, probably rightfully so, will bend over a little backwards to help them out, and they don't know the rules. And so it's like, I can't respond to an argument that we all know doesn't make any sense, but I can't articulate it because
it doesn't make sense. Yeah. And so that's exactly right. I found it to be a lot more difficult. Now, one thing that happened in this trial is, it was sort of like the husband was the leader and then wife was more of the follower. All the opening statement and closing arguments were both done by the husband. He was a very abrasive, very rude, very inarticulate man, but smart. He'd already gotten his dog out of trouble in municipal hearings multiple times, and essentially his luck ran out. And so he tried to conflate the civil proceeding, that hearing, that trial, which was only about negligence and was to award damages to our client with, oh, well, this dog's going to be put down. So we had to deal with that, which is improper, obviously. And it's misleading the jury. And then he repeatedly accused us of hiding things or said, well, these slick lawyers and we don't know the rules. And so again, theater. In that situation, I told my trial partner, every opportunity that we have to be helpful, we must take advantage of. Here, let me help you work the Elmo. Here, let me explain to you. In fact, in front of the jury, I walked through how a closing argument works with the pro se defendant and said, first, you're going to give a brief statement. Then you're going to go through each question and you're going to suggest an answer for each question. And that's not only the right thing to do when someone doesn't know, but it also tells the jury that's BS. We are actually doing this the honorable way. And after the defendant did his closing argument, I had the idea of looking at my phone, and while the jury was waiting, and I Googled gaslighting, and I told them, now, first of all, we're being accused of being slick lawyers, and that we're trying to pull the wool over your eyes, that we're hiding evidence. None of that is true. You'll see all the evidence. We've only highlighted some of it for you. But I also want to highlight this. Throughout the whole trial, the defendant, Mr. Rodriguez was his name, has been gaslighting you, and he's gaslit my client. And in the interest of full transparency, I don't want to give you my definition of gaslighting. So I went ahead and looked it up. I read them the definition, and it was misleading someone for one's own gain was the one that I found. So if that is not gaslighting, I don't know what is. So essentially, and again on themes, I'm going a little all over the place, but as anyone who's tried cases knows, a theme is very important. And you got to start with it. If you can talk about it in jury selection, even better. And you've got to sprinkle it in your questions, in your opening, in your questions, in your closing. It's got to be it's got to be what they think about when they see the key piece of evidence according to your case. And in that one, it was a series of bad choices. We had gone back and forth between the word decision and choice. And I said, no, the word choice is a lot better. And basically, these two defendants, they get it. They adopt a dangerous dog, which is arguably a bad choice right there. Then they choose not to train the dog for multiple years. So each year passes and they choose not to train the dog. Then the dog is aggressive towards someone. They don't train it. Then the dog bites someone else. They don't train it. So we had all these series of bad choices. And, one thing for someone who's wants to learn some tips on how to take over the courtroom and use space in a situation like that, our whole thing was there's a timeline of bad choices. And so what I did was I started on the left side of the room, and here's one choice. Take a couple steps. Here's another choice. And if you can show the jury what your point is by taking advantage of the space in the room, not only does it help calm nerves that happen to just about anybody during a trial, but it also helps you get your message out there. And to me, visuals, whether it's you using your arms and or using your hands or using the room, using PowerPoints, that kind of stuff has been very effective in my opinion.
Good. And I got to give you credit because all three of these were challenging as far as you probably on the TTCA, your max recovery is 100,000. The other two, you clearly weren't insured. And so I give you credit for trying a case that a lot of lawyers would say, yeah, I'm sorry, I can't help you because there's just no money to be had. So that's a real credit to you and your partners on those cases. All right. Well, and I talked to a lawyer on the way over here today who told me that you had talked to him like, hey, I'll try anything that's ready to go get tried. Let me have it. And he's like, okay.
That's right. And for anyone who's listening to this, if you want somebody to help you try a tough case, give me a call. I'm happy to do it. And, another thing I want to say about the firm generally, if I may, is, our mission is bigger than just getting great results for clients and being, relentlessly available. Yeah, to me, it's all about giving back. So my firm, I'm very proud that a portion of every settlement, or verdict, or the fees therefrom, more specifically, will be donated to some kind of nonprofit organization. And, it may be big, it may be small, but to me, that's sort of the anchor of why we do what we do. And I really wanted to, when I started this firm, I wanted to show that, this whole idea that plaintiffs' lawyers are greedy and we're, money hungry ambulance chasers is not true. So, and I know that you can be very successful and have a comfortable life and do anything you want to do, have the things you want to have, but also make a big difference. Because to me, more resources is not only a better lifestyle, but also the ability to help more people and make a bigger impact in the world.
Well, good. Well, I hope you are in a position, and I know you will be, to give out a lot of portions of large fees.
That's the plan.
All right. Well, very good. Well, Steeves, thanks for joining us. I think there was a lot of good, or not us, just me today, since my colleagues too busy for us. But I really appreciate you joining me to talk about a lot of really cool stuff and cool experiences and really good advice for young lawyers.
Thank you very much. And to those of you who are considering going out on your own, anonymously, you can reach out to me, or in confidence, I should say, reach out, send me a DM, reach out to me by email. Happy to talk you through it. If you're thinking about doing it, I say go for it.
Yeah, good. Yeah, follow you on LinkedIn.
That's right.
You post a lot. All right. Well, thanks, Steeves. I think we covered your website at the beginning and all your social media stuff.
That's right. Thank you, Peter.
Yeah, you got it. And so if you like this or you want to follow us, check us out on all the different platforms: Apple, Spotify, YouTube, Instagram, Facebook, and of course, LinkedIn. All right. With that, we'll call it a good night. Thank you.